I think oftentimes we need to understand and we need to remind ourselves that there are corporations and businesses out there that may preach that they're for you and they want to do good by you, but at the end of the day they're only in it for the bottom line. They're just to up their money, and if it means screwing you over or you compromising some sort of sense of security or privacy, they are going to take advantage of that. We have businesses that pursue infinite growth, and if it means screwing you over at the end of the day just to get some sort of growth to appease to investors and shareholders, they will definitely do that. And with that said, we definitely need to talk about the situation going on with Disney trying to throw away a wrongful death lawsuit because because this person subscribed to their Disney Plus service. The couple, along with Piccolo's mother, went to dinner on the night of October 5th at Raglan Road Irish Pub, a restaurant located within a shopping and dining complex called Disney Springs. Basically, we're looking at the Piccolo family, Mr. Piccolo, and then you have the mother, and then also you had Piccolo's late wife, Tang Swan. I believe I'm pronouncing that name correctly. I do apologize if I butcher it. Was highly allergic to dairy and nuts, and they chose that particular restaurant in part because of its promises about accommodating patrons with food allergies, according to the lawsuit filed in a Florida circuit court. The complaint details the family's repeated conversations with their waiter about Tang Swan's allergies. The family allegedly raised the issue up front, inquired about the safety of specific menu items, and had the server confirm with the chef that they could be made allergen free, and asked for confirmation on quote several more times after that. This is pretty standard. I think all of us know somebody that has some sort of allergy. You're going to do a little bit of research when it comes to dining anywhere, and you're going to say, hey, listen, I myself or maybe somebody else have these allergies. Can you accommodate to patrons that have these allergies? And a restaurant will let you know straight up, and in their interest, of course, because everyone needs to be protected here, yeah, we do accommodate to those patrons, and no, they don't. So I feel as if this family is doing their part or doing their research to ensure that, Tang Swan is, completely safe when it comes to eating in these establishments. When the waiter returned with Tang Swan's food, some of the items did not have allergen-free flags in them. And Tang Swan and Piccolo once again questioned the waiter who, once again, guaranteed the food being delivered to Tang Swan was allergen-free, the lawsuit reads. Sorry, I'm getting tongue twisted here. The three of them ate and then went their separate ways. Piccolo brought the leftovers to their room, and while his wife and mother headed for the stores. After about 45 minutes, Tang Swans began having severe difficulty breathing and collapsed to the floor. She self-administered an EpiPen, and an observer called 911. The Piccolos, who have tried calling her multiple times, were eventually told she'd been rushed to the hospital. They went to meet her, and after a period of waiting, were told that she had died. I think this is a very traumatic situation. As a matter of fact, not even I think. It is traumatic. And especially since you done everything that you could to ensure that your loved one is safe when it comes to consuming food, and only for them to be failed during that process is heartbreaking, and it's definitely heart-wrenching. Someone in the process between you doing your research on this food establishment and making sure everything is a-okay on their end, to the food being put in front of her and letting the waiter know, like, hey, are you sure this doesn't have dairy? Are you sure this doesn't have nuts in it? And the waiter said, yes, I confirmed it with the chef, I did my thing, yada yada yada. Something happened in that process, and that result in failure. And now your wife is dead. Of course, I can only imagine how their family feels, because I know somebody, maybe you know somebody that have allergies. And imagine you and your loved one and people around you do your part only for it to still fail regardless. There has to be accountability here for this. The medical examiner's investigation determined that Tang Swan's cause of death was a result of anaphylaxis due to elevated levels of dairy and nut in her system, according to the lawsuit. Piccolo filed suit in February against Raglan's Road Irish Pub and Walt Disney Parks and Resorts US Incorporation, or WDPR, accusing both companies of negligence for preparing Tang Swan's food improperly and for failing to train their employees to guarantee food was made allergen-free as requested. He is seeking more than $50,000 in damages and trial by jury on all issues so triable. Personally feel, this is a personal thing, that this is very normal. If you was hurt or someone died because of an allergy, and the doctor even confirms, or the medical examiner confirms, that yes, this person did suffer an allergic reaction, yeah, you would think that you would sue this company. I think everybody would do something like that. Like, hey, you are responsible for this person's wrongful death. You should be held liable for things like this. I don't think there's anything wrong with that. But for some reason, Disney refuses to accept that accountability. In late May, Disney's lawyers filed a motion asking for Circuit Court to order Piccolo to arbitrate the case with them and a neutral third party in private as opposed to publicly in court, and to pause the legal proceedings in the meantime. Arbitration is generally considered a more efficient and cost-effective method of resolving disputes than litigation, and Disney said explicitly in court documents that the, unquote, main benefit of arbitration is avoiding heavy litigation costs. The reason it says Piccolo must be compelled to arbitrate, a clause in the terms and conditions he signed off on when he created a Disney Plus account for a month-long trial in 2019. That has to be the craziest defense that Disney can just pull from the darkest crevices of their rectal cavity. I think there's something genuinely wrong here. Basically, what Disney is saying is they're saying, hey, you can't sue us and bring us to court because you accepted the terms and conditions or the terms of use when you made a free trial account with Disney Plus on the year 2019, which was 5 years ago. So he's not even an active member of Disney Plus or anything like that. They're taking a trial, a free trial. It's not like he paid the money and they're saying, yeah, because you agreed to this term 5 years ago, you can't sue us. Now, you can arbitrate the case, and they already explained it. It means, hey, we have a third party that's very neutral on the matter, and we would rather discuss things in private too, and we want to mitigate any heavy costs when it comes to legal proceedings. He's only asking for $50,000. Give him $100,000, $500,000, and I promise you, Disney, it would not break your bank. Those terms of use, which users must acknowledge to create an account, state that any dispute between you and us, except for small claims, is subject to a class action waiver and must be resolved by individual binding arbitration. Disney says Piccolo agreed to similar language again when purchasing park tickets online in September of 2023. Whether he actually read the fine print at any point, it adds, is immaterial. Piccolo ignores that he previously created a Disney account and agreed to arbitrate all disputes against the Walt Disney Company or its affiliates arising in contract, tort, warranty, statute, regulations, and other legal or equitable basis, the motion reads, arguing the language is broad enough to cover Piccolo's claims. What Disney is saying here is that even if the Disney Plus situation is irrelevant to the whole wrongful death case that they have going on here, he bought a ticket that has similar language when it comes to not being able to sue Disney and bring them into court. So it's safe to say that because he bought the tickets, there's a stronger argument here than there is at Disney Plus. But even then, why even bring up Disney Plus to begin with? The fuck does Disney Plus have anything to do with your wife eating at a restaurant, eating a food that she was allergic to, and the establishment said there's no allergens, you're good, we verified everything, and she died an hour later after the fact? What does Disney Plus have to do with that? It is absolutely irrelevant. In early August, Piccolo's lawyers filed a response slamming Disney's rationale as preposterous, bordering on the surreal, and fatally flawed for numerous independent reasons. There is simply no reading of the Disney Plus subscriber agreement which would support the notation that Mr. Piccolo agreed to arbitrate claims arising from injuries sustained by his wife at a restaurant located on premises owned by a Disney theme park or resort, which ultimately led to her death. They wrote in a 123-page filing. They confirmed that he did create a Disney Plus account on his PlayStation in 2019, but he believes he canceled the subscription during the trial because he hasn't found any charges associated with it after that point. And I agree, it's completely out of touch that Disney would take a subscription agreement from Disney Plus and try to apply it to a wrongful death at a restaurant. The only reason that Disney is in this is because this is a Disney establishment. This is the property of Disney. There is a restaurant here, so Disney must have some sort of association or liability here when it comes to that restaurant, catering to their customers. And again, I'm still circling back to why Disney can't just give them $50,000. Like, just give it to them. Just give them $50,000. Why are we so serious about this? Piccolo's lawyers accused the company of trying to deprive Tang Xuan's estate of its rights to a jury trial. The notation that terms agreed to by a consumer when creating a Disney Plus free trial account would forever bar that consumer's right to a jury trial in any dispute with any Disney affiliate or subsidiary. It is so outrageously unreasonable and unfair as to shock the judicial conscience, and this court should not enforce such an agreement, they wrote. Piccolo's lawyers also took issue with the process itself, saying Disney didn't raise its alleged right to arbitration early enough in the proceedings. They further note that Piccolo did not bring the lawsuit as an individual, but on the behalf of the Tang Xuan's estate, which did not sign off on any such terms. There is no such estate at the time, since Tang Xuan was still alive. So basically, what Piccolo's lawyer is arguing here is that, okay, let's say we go by the rules. Let's say we play into Disney's, home field territory here. Let's say Mr. Piccolo here doesn't have the right to sue Disney and bring him into public court by jury trial, whatever. Tang Xuan, his late wife, never agreed to those terms, because at the end of the day, it was Mr. Piccolo that subscribed to Disney Plus, not Tang Xuan, his late wife. He's just representing her because she's dead. Like, that's really it. And plus, there was also a good argument that someone brought up, is that sometimes when you accept the terms and conditions, there are things that are reasonable, quote unquote. And when they say reasonable, it means you kind of have to understand that, yeah, they have the right to do this because they are that business, they're that company. So if you was to make a Facebook account, for instance, let's just say Facebook, and you're making an account and you have the terms and conditions that you read, one of those things that they may say in the terms and conditions on Facebook is, hey, we have every right to information that you put on Facebook. We can use it for advertising or marketing or whatever. They have rights to these things. That is considered reasonable. Nowadays, we're trying to fight for that privacy or the right to regulate, how big corporations like Meta and Twitter is using our information, especially sensitive information. But as of right now, what's going on here is reasonable. They're able to do that. Now, if Facebook was to do you dirty in some way, shape, or form, and Facebook says, oh no, you can't sue us for that, because you made a Facebook and yeah, maybe you deactivated it or something like that, but you agreed to our terms and conditions years ago, so we own the rights to that data. It is absolutely fucked up. There is no reason that anyone would look at terms and conditions and say, oh, I can't sue you when I use your service? Shoot, sign me up. I don't think that's reasonable. That is not reasonable. There's no way a person would read something like that and would just forfeit that right. You could be a die-hard fan of Disney. I don't think a person would sign off that right. I don't think so. It's just absurd to me, and it's absolutely outrageous till this day. And it's crazy that Disney is even putting up this defense to begin with. But now, apparently, they're going to continue with this, court thing on October 2nd. I don't know what's going to happen then. It's not too long, but we may hear something about it, you know, sometime then, and maybe I can even revisit this and see what the final result of all this is. And hopefully Mr. Piccolo and, you know, Tang Xuan's, you know, relatives could get, you know, some peace of mind. You know, they can move on from this, because this whole situation is dystopian and it's absolutely fucked. But until then, that's about it, y'all. Peace.